Welcome to this video. We are law students who created this video in partial fulfillment of our requirements in legal technique and logic. Note that we are not experts in this field and therefore majority if not all of the materials included in this video were taken from the internet, which were published by more credible people than we are. Yes, this video will be simple, but will surely be informative. Without further ado, let's get into this video. This video will briefly discuss the definition of fallacy, together with two general types of fallacies, namely formal and informal fallacies. A subgroup under informal fallacies is referred to as fallacies of weak induction. Fallacies of weak induction includes appeal to unqualified authority, appeal to ignorance, and hasty generalization, which will be discussed in detail. So, what is fallacy? Fallacy, by definition, is reasoning that is evaluated as logically incorrect and that undermines the logical validity of the argument and permits its recognition as unsound. In other words, a fallacy is the use of invalid or otherwise faulty reasoning in the construction of an argument. Fallacy can occur as accidental or can be deliberately used as an instrument of manipulation. So the two general types of fallacies are, the first one, formal fallacy. A formal fallacy is an error in logic that can be seen in the argument's form. However, informal fallacies are arguments that are fallacious for reasons other than structural or formal flaws and that usually require examination of the argument's content. A subgroup under informal fallacies, as I mentioned earlier, is referred to as fallacies of weak induction. Fallacies of weak induction can be simply termed as problematic inductive arguments. The fallacies of weak induction are arguments whose premises do not make their conclusions very probable, but they are very successful in convincing people of their conclusions. The premises do not provide nearly enough logical evidence to support the conclusion, though there might be emotional reason to believe it. The fact that there isn't a really strong connection between premises and conclusion is hidden in some way. Appeal to unqualified authority, also known as appeal to false authority. This fallacy is described as a fallacy that uses an alleged authority as evidence in your argument when the authority is not really an authority on the facts relevant to the argument. So if you're the audience, what you're doing is that you are allowing an irrelevant authority to add credibility to the claim being made. In simple terms, it is a fallacy that persuades others by appealing to people who command respect or authority but do not have legitimate authority in the matter at hand. What we need to remember in this fallacy is that the recognized expert do not actually have the legitimate authority in the matter being discussed. There are three main types of false authority, each of which represents a different reason why someone's authority is invalid. So the pattern of our discussion will be the type of false authority followed by the reason why someone's authority is invalid, and an example will be given at the end of each type of false authority. So the first type of false authority is a false authority with dubious credentials. This occurs in cases where the supposed authority figure does have some sort of relevant credentials, but these credentials are of questionable quality. The classic example is a homeopathic doctor with no formal medical training who is discouraging the use of conventional treatment. The second type of false authority is a false authority with irrelevant credentials. This occurs in cases where the supposed authority figure does have valid credentials, but note, these credentials are irrelevant to the discussion at hand. For example, a physics professor who tries to give out medical advice despite having no medical training. And the last one is a false authority with no credentials. This occurs in cases where the supposed authority has no credentials at all. For example, a lay person with no medical training at all who tries to give out medical advice based on his uninformed opinion. So, we must remember and take note that false authority can be ascribed to entities other than people, such as books or companies. For example, people often use things which are written in holy texts in order to support their arguments. It is a concept known as the appeal to Holy Scripture, under the assumption that those texts contain knowledge which is based on divine inspiration. In order for us to easily remember what appeal to false authority is, it is necessary for us to understand its logical form. According to person 1, Y is true. Therefore, Y is true, despite the fact that person 1 offers little or no expertise on Y being true. The following will be examples in which the logical form can be easily identified. Example number 1. My 5th grade teacher once told me that girls would go crazy for boys if they learn how to dance. Therefore, if you want to make the ladies go crazy for you, learn to dance. So the explanation for this example is that even if the 5th grade teacher were an expert on relationships, her belief about what makes girls go crazy for boys is speculative or perhaps circumstantial at best. In other words, the teacher's expertise is in dance, not on the psychology of attraction. Example number 2. The doctrine of biological evolution cannot be true, for it contradicts the biblical account of creation. The church fathers never accepted it, and the fundamentalists explicitly condemned it. What is wrong in the argument above is its reliance to certain authorities who, although respected, are not the appropriate authority on this matter since the issue is about science. Another type of inappropriate authority is a biased one. It means some people may be qualified in a particular field, yet they are vitally interested in or affected by the issue at stake that there would be good reason to treat their testimony with suspicion. An example is Jose Javier Reyes, director of the movie Live Show, said in a press conference that MTRCB has unjustly banned the movie from being shown. According to Reyes, the movie is not pornographic since it has a very relevant plot and a well-written storyline. Since Reyes is a veteran in Philippine cinema, we can say that indeed, MTRCB acted wrongly in banning the said movie. Well, what we can say in this example is that despite the fact that Reyes is qualified in the field in issue, yet he is vitally interested in or affected by the issue at stake, that there would be good reason to treat his testimony with suspicion. So, a common situation where people rely on false authority is when celebrities endorse various health products in media, since people listen to their opinion even if it's entirely unqualified simply because they look up to them in general. Example number 4, movie star. The peanut butter and celery diet is a great way to lose weight. Buy my new book for instructions on how to do it. Homeopath. I've studied these types of illness for many years, so I know a lot about the topic, and I've seen time and time again that homeopathic treatments can be far more effective than conventional cures. Warning! These examples also demonstrate the fact that people often ascribe authority to themselves in cases where they shouldn't, and self-proclaimed experts often use the appeal to false authority when promoting various pseudoscientific concepts.
Appeal to ignorance or argumentum ad ignorantiam. This fallacy arises when one is assuming that something must be true simply because it has not been proved false, or when it is argued that something must be false because it has not been proved true. In other words, it consists in assuming that a particular claim is true because its opposite cannot be proven. It is the using of the absence of evidence against a claim as justification that it is true. This is an assumption of a conclusion or fact based primarily on lack of evidence to the contrary, usually best described by absence of evidence is not evidence of absence. There are two logical forms of this fallacy. First, there is no evidence against X, therefore X is true. This is an affirmative logical form. It asserts that a particular conclusion must be true since there is no evidence against it. And number two, there is no evidence to support Y, therefore Y is false. This is a negative logical form. It declares a conclusion false because of the lack of evidence for it. And typically, appeal to ignorance fallacy involves in three parts. First, initial statement that some claim has not been proven false, or there is a lack of evidence showing that P is false. Second, unstated assumption, and for example, this absence of evidence is evidence that P is not false. And last one, the conclusion, therefore P is true. An example of this, you cannot show that ghost doesn't exist. The fact that you can't show that ghosts doesn't exist is evidence that they do exist. Therefore, ghosts exist. The first statement is the initial claim where they claim that there is no evidence that ghosts exist or doesn't exist. The second statement shows that there is an assumption that the no evidence is evidence for ghosts to exist and thus therefore ghosts exist. Appealing to ignorance arguments come in a variety of different forms, and these are other examples of the appeal to ignorance fallacy. No one has ever proven that God does not exist, therefore God does exist. Second, you cannot show that you didn't steal a cookie from the cookie jar, therefore you did. And last example, there is something in the sky but I don't really know what it is. I can't really prove that it isn't UFO, therefore it is. The appeal to ignorance fallacy is committed when we reason from an absence of evidence to some definite conclusion. However, we routinely reason from there being evidence that something is absent to positive conclusion. Arguments that make use of an evidence of an expected absence do not commit the appealing to ignorance fallacy because they do not treat our lack of evidence or ignorance about something to some positive conclusion. Example of this, absence of evidence. There is no evidence that it didn't rain. And besides, you can prove that the ground is wet 5 minutes ago, therefore it rained. And in evidence of absence, whenever it rains, the ground is wet. The ground is not wet, therefore it did rain. There are times when the absence of evidence may prove or disprove a claim. Keep in mind, however, that this occurs when there are standard methods of proof that are available and have been used, but there is a failure to prove or disprove a claim. For example, in a case, after a thorough inspection of the house, the pest control specialist cannot find flying swarms of termites, maze-like patterns in the floorboards or walls, crumbling or damaged wood, or peeling paint that resembles water damage, or etc. If there is an infestation of termites, then we would find XYZ. We do not find XYZ, therefore there is no infestation of termites. In this case, it would be logically justifiable to conclude that from a lack of evidence of the presence of termites, there is likely no termite infestation in the house. While this may appear to be an argument from ignorance, the difference is important. The negative inference, which is the no signs of termites, is based on an evaluation of the evidence. Other examples of the reasoning from evidence involving an absence. Example 1, I've seen many patients that have the T virus. When the T virus is in your system, you will turn to a flesh-eating zombie in 1 hour. Well, it has been 5 hours since you have been bit. I think it is safe to say that you don't have the T virus. Example 2. A guilty man always denies his guilt. The man we have been interrogating for the last 5 hours hasn't denied that he is guilty. Therefore, he must be innocent. Here, the examples, before they conclude with a negative inference, they support their claim with an evaluation premise. Thus, these examples do not commit the fallacy of appeal to ignorance. Generally, when an individual has the responsibility to show that a claim is true, we say that this individual bears the burden of proof. It is up to them to prove that the claim is a case, not up to those who don't accept the claim. And who bears the burden of proof? The individual making a claim bears the burden of proof when the claim they are making is not common sense or when it is controversial. And the individual contesting a claim bears the burden of proof when the claim they are contesting is common sense. Examples of this: in the individual making a claim, in law, if the state thinks John is guilty of murder, then the burden of proof is on the state to prove that John is guilty. It is not on John to prove that he is innocent. In the individual contesting a claim, John speaking that the sky is blue, and then Vic said, I don't believe you, prove it. Here, in this example, Vic is contesting a common sense truth, thus Vic has the burden of proof. In a criminal proceeding, a defendant is innocent until proven guilty. And why is that? If the appeal to ignorance fallacy were a legitimate form of reasoning, then it would be possible to prove an infinite number of absurd things. For example, you can prove that there isn't $1,000,000 in my house, therefore there's $1,000,000 in my house. Number 2, you can't prove that you didn't cheat on the last exam, therefore you did cheat on the last exam. You deserve an F for the course and will be expelled from Penn State. Lastly, John claims he was asleep in a hotel 100 miles away from the crime. He can prove that he isn't lying, so he can prove that the hotel receipts he gave us aren't forgeries, and so he can't prove that he wasn't at the scene of the crime, and he also can't prove he didn't stab Mary with a knife and then hid it in a place that no one can find it. Therefore, John is guilty. In the last example, individual liberty is fundamental. Incarcerating someone would put a limitation on their liberty. Thus, the state requires strong reason or proof that there is a good reason to limit someone's liberty. Examples of appeal to ignorance fallacy in court decisions. In Board of Trustees of the Fire and Police Employees Retirement System versus Powell, the court's reasoning apparently rested on the fallacy of argumentum ad ignorantiam. In Powell, the trustees of a fire department retirement system challenged the award of disability retirement to a firefighter who had contracted hepatitis B. The hearing examiner awarded the firefighter the disability retirement, accepting the firefighter's argument that since he was free of the disease when he was hired as a firefighter, and since there is no indication or explanation of how he might have acquired the disease other than through his contacts with victims who he was required to treat as part of his emergency medical technician duties, his incapacity should be held to arise out of and in the course of the actual course of his job. On appeal, the court held that the firefighter failed to establish that his hepatitis had been caused by events related to his employment. As the court acknowledged, the law requires proof of probable, not merely possible facts, including a causal relationship. Reasoning post hoc, propter hoc, is a recognized logical fallacy, a non sequitur, but sequence of events plus proof of possible causal relation may amount to a proof of probable causal relation, in the absence of evidence of any other equally probable cause. The Powell Court recognized that more is required to indicate a probable causal relation than simply eliminating other suggested causes. In this case, inferring that the cause stemmed from a work-related event by eliminating other possible causes would have been an argumentum ad ignorantiam. other common confusions in this fallacy, defendants choosing not to testify. Here, the prosecution puts forward a weak case against John consisting mostly of shady witnesses claiming John killed Mary. John decided not to take the stand. If this is taken as an indication that John killed Mary, then the jury is placing the burden of proof on John and committing the appeal to ignorance fallacy. The jury's reasoning here is as follows. You didn't testify and prove you are not guilty, therefore you are guilty. This reasoning is incorrect because the defense does not bear the burden of proof and does not need to show that the defendant is not guilty. In conclusion, appeal to ignorance is based on the assumption that the absence of evidence is, in fact, evidence that supports either the truthfulness or falsity of the conclusion. But in reality, however, appeal to ignorance only shows that we don't know something. If this type of argument was valid, it could be used to support two opposing arguments, which is an obvious clue that it is based on flawed reasoning.
Hasty generalization or converse accident. A hasty generalization is an inductive generalization where the subgroup referred to by the premise is non-representative, which means that it presents the assumption that whatever it is that the subgroup means applies to that of the whole population. It creates a non-representation of the truth for the whole population because the sample based from is insufficient to prove the truth behind the conclusion stated, concluding that what is true for a certain idea is true for all that represents it. In the case of Leak versus Casati, this is a court ruling that presented a hasty generalization where the county argued that if the subdivision ordinance was inapplicable, then all local ordinances were also inapplicable. The generalization that all local ordinances are inapplicable because one specific ordinance is inapplicable is an exceptionally hasty generalization. The court stated that it does not follow that those who become owners of the resulting parcels will be immune to valid laws regulating land use. It is important to remember that the application of a general rule to a specific situation is a fallacy only when the rule is inappropriate because of the accidents of the specific situation. Similarly, the formulation of a general rule is a hasty generalization only when the situation leading to the formulation of the general rule is special and not general. Courts regularly extend rules to encompass a wider variety of situations, thereby creating a more general rule. Such generalization is hasty only if the original rule was based on specifics not present in the case to which the rule is being extended. An argument commits the fallacy of hasty generalization if it is an unsuccessful inductive generalization, wherein the argument presented is more likely than not. The presented argument has the probability of being false due to the insufficiency of basis of the argument presented, therefore creating an unsuccessful inductive generalization. One commits the hasty generalization fallacy when one makes an inference based on an insufficient number of particular premises, when one is too quick or hasty in inferring the general conclusion. Stating a premise without an enough claim to support it leads to a conclusion that generally does not represent the truth for the overall population of the assumption. In short, the smaller your sample group and the less diverse it is, the less sure we can be about making generalizations based on the group sampled. When we rely on anecdotal evidence to make decisions, we commit the fallacy. Many people are susceptible to hasty generalization in their everyday lives. For example, you want to buy a specific model of an iPhone, and your friend has that particular model, so you ask your friend how he likes his iPhone. He states that it's awesome and that he doesn't experience any problem with it. You then conclude that iPhones must be a great phone. But one person's testimony isn't enough to justify that conclusion. You have to look at other informations and sources regarding the actual functions of the phone and its pros and cons to reach a conclusion that represents the whole. This kind of conclusion is based on an anecdotal evidence. What then is an anecdotal evidence? Evidence collected in a casual or informal manner and relying heavily or entirely on personal testimony is an anecdotal evidence, which was shown in the example earlier. Let us now look at the structure of a hasty generalization. The structure of a hasty generalization starts from the premise wherein one A is a B or a few A's are B's, leading to a conclusion that all A's are B's. The conclusion asserts a considerable generalization given the small amount of evidence in the premise. Although the premise is relevant to the conclusion, it is insufficient to support the generalization in the conclusion. Make a case that the argument is weak induction and indicate the type of evidence is needed to make the generalization stronger. So let's try an example that is based on current events in the Philippines. Recently, Fallacies speaker Salvador Panelo caused a stir because of his statement regarding the prevention of the current COVID-19. He stated that bananas are a good way to fight viruses. Therefore, eating bananas will help kill the coronavirus. As what I have stated earlier, there is a hasty generalization when it results to an unsuccessful inductive generalization. Here, though it is true that bananas are in fact beneficial to eat, it does not represent the general assumption that it can fight off all kinds of viruses, including the COVID-19. The basis of the Fallacies speaker Salvador Panelo on his statement came from unnamed articles which does not sufficiently support the conclusion that the Fallacies speaker Salvador Panelo tried to purport. Next example is a statement of Senior Superintendent Bernard Banach, which is the PNP spokesman. He initially stated that villages formerly infected by drugs are now cleared, therefore leading to a conclusion that the drug war is still a success. Simply stating that because some villages are now cleared from drugs, it cannot be used as a representation of the entirety of the truth of the current war against drugs of the Philippines. It does not present sufficient data to prove that it is in fact resulting to the eradication of drugs in the country. The premise is only true for the certain villages that they were able to penetrate and clean, but for the entire country, which is under the drug war of the administration of President Rodrigo Duterte, it can't be a representation of the true status or if the drug war is proving to be successful. So why do we have hasty generalizations? Exaggerated, quick generalization often occur when people try to adjust to confusing and controversial event. The earlier examples presents the current events in the country where the people are still trying to grasp or trying to understand whatever it is that's happening, which results to a hasty generalization that are sometimes even broadcasted in live television. So why do we have to know about hasty generalization? The importance of knowing hasty generalization as a fallacy to avoid understanding hasty conclusion cautions us not to jump into conclusions in proposing new ideas or hypotheses. Thank you.